for delivery of judgment WPC 2639/2017.
In view of the facts and circumstances of the case, we are of the opinion that the final order dated 36/2016 passed by the Learned Foreigners Tribunal 7 Dhubri does not call for any interference. So it's dismissed.
Yes. Item. Right. 15. Also, is a representative of the prayer made by Land Council for the petition in the Judge John today. List on 3/2/2026. On 3rd February. Item number 15.
Eight, your lordship.
6, 7, 8.
Lordship, yesterday I have circulated adjournment slip, your lordship. Learned arguing counsel Mr. A.W. Aman is on leave, your lordship.
6, 7, and 8. Same date, 2nd of February. Next day.
Highly obliged.
Okay. Next.
May I please, your lordship? I would like to beg to mention a listing of a writ petition criminal.
Listing 24.
May I please, lordship? I beg to mention item number 5, Miller.
5, you'll have to wait.
Yes, Miller.
2017.
In this case, Miller, file is not test out, Miller, yesterday night.
But this 2017 matter, we are not
That
adjourning.
Miller, then Miller, I have to collect the office copy of my opposite.
Whatever, you can take the, take our copy for the.
Yes,
time.
Miller. Yes.
We have some time.
Yes,
In
yes.
meantime, go through it.
Publish.
Give our file.
Admission item 1 with item 2.
Wait, please. It was very good. My lord, for the purpose of convenience, if your lordship should kindly take item number 2, my lord. I'll explain, my lord, there is not much of a difference.
A moment. Just a moment.
Yes.
So, appeal of order of 2022.
Yes, my lord. Actually, my lord, appellant 1 to 5 in writ appeal number 12 of 23, they were promoted, and my lord, appellant number 6 to 10, who are appellant in item number 1, they were upgraded. This is the difference. appellant number 6 to 10 in writ appeal 12 of 23 are the appellants in Millard. Writ appeal number 53 of 25. Because this honorable court, Millard, was of the view, a division bench of this honorable court, that since appellant number 6 to 10 were upgraded, therefore we should file a separate writ appeal. Leave was granted. That is how, Millard, writ appeal 53 of 25 came to be instituted. Otherwise, Millard,
Who is the writ petitioner?
writ petitioner, my learned friend represents Millard. He was
Their case is-
not in the zone of consideration.
No, they are saying that the promotion was against the recruitment rules.
That's the point. Precisely. And I'll demonstrate, Millard, that is the view taken by the learned single judge is absolutely wrong, Millard. This
Why?
is not how, Millard, it is wrong because the upgradation provision is there, statutory provision is there.
Can we see that?
Yes,
Where is that?
yes. Millard, last occasion we have given that Pollution Control Board regulation of 2012.
Yes, it's available.
Yes. Please come to me, Lord, regulation number 4. Yes. Board may by resolution may upgrade or downgrade posts within the sanctioned strength. However, by addition to the existing strength of the cadre shall be with the approval of the government of Assam. Government approval is there. Pay benefit was given. Milord, it is a decision taken. What had happened, Milord? We were, Milord, not degree holders. We are diploma holders. Now, Milord, the Central Pollution Control Board took a decision that the junior engineer post should be abolished. Now, if your lordship would kindly, what is the background? If your lordship should kindly come to, now, Milord, the matter is very simple. Since your lordship has taken the regulation, please have that regulation, Milord.
But I'm
Please
just
come.
asking you a question before you proceed.
Yes,
You see this, the Engineers Association case,
yes.
2. in
Number
that-
2.
Number 2.
It appeal the
No,
second.
no. The Engineers Association that 2, what is it called? That case is,
Oh, well, that is in slightly in a different context.
okay.
That is slightly in a they different. Here, my lord,
Difference between diploma and that is dealt
no,
in that
but
case.
that is in a different context. Here it is in a different context.
Okay,
That is why. Lord.
please explain that.
Now, the background is very clear. If your lordship should kindly come to page 247 of the item number 2.
147.
247 of item number 2.
Yes.
Kindly see, my lord, minutes of the 75th board meeting held on 19 June 2001 in the office chamber of the chairman, Pollution Control Board, Assam. Now, my lord will kindly come to page number 251. Upgradation of the post of junior engineer to assistant engineer as per Central Pollution Control Board norms.
Yes.
The member secretary apprised the board that as per Central Pollution Control Board, no diploma engineers should be recruited and the existing diploma holders should be upgraded from the post of junior engineers to assistant engineer, aiming at increasing efficiency of engineering service of the board in future. The Central Pollution Control Board also desired the state boards to follow the said policy. The matter was discussed. Board agreed to the policy in principle, but considering the present financial position of the board, it is resolved to upgrade those posts of junior engineer which have confirmed eligibility of norms phase-wise. B. A. Board will not fill the present vacant post of assistant engineer till it is decided by the board otherwise. Member secretary of the board will submit service sheet of the upgraded engineers person-wise, specifically mentioning the period of qualifying service, the scale of pay, basic pay, departmental proceeding, if any, of the junior engineers for final approval of the board. So, my lord, it was a decision taken to increase the efficiency of administration. The Central Pollution Board said that do away with the post of junior engineers and don't recruit assistant engineer until you upgrade them. This is the decision in principle, my lord. Pursuant to this is of 2001. Second read appeal. 251. হ'ব এনেকেতো কেছ কৰি আহিলো এনেকে এপিলত ষ্টে ললো এইটো পঢ়ি পেলাই তুমি কোনটো পঢ়ি আছা নাই read the other one. I'm saying I'm read appeal 12 পঢ়ি আছো মই এতিয়া Now, my lord, kindly come to page 147. December 2005.
Yes.
Under section 22A of Water Prevention and Control Pollution Assam Rule 1977, as amended, the following 14 junior engineers of this board, having experience of more than 10 years of service, are upgraded to the post of assistant engineer with immediate effect. My lord, I may just indicate, my lord. Out of these 14, 10 are the appellants. Now, my lord, this order was never challenged. This order attained finality. Now, because we are assistant engineer, therefore, my lord, we are sought to be promoted as assistant executive engineer, which in fact we have been done. Now, December 2005, we were upgraded. Now, my lord, what is the meaning of upgradation? Are we to understand? Now we cannot become assistant engineer, executive engineer. We cannot become executive engineer. My lords, that's why Supreme Court says equity knows no halfways. If I am assistant engineer, then I am assistant engineer for all practical purpose. It is not a case where there is violation of any statutory rules. The statute itself prescribes that power.
This suspect, how is that being dealt with?
It has not been dealt with properly, my lord.
Was it raised?
No, Lord, Lanet Single Judge has gone very technically. Yes, we do not have B. We are
It's
not.
okay, but what is the pleading in the writ petition?
Yes, that's very important. Now, my lord will kindly come to for that. The case of the writ petitioner, I am very obliged. Please come to page 69, my lord. This is their case, para 24.
When you read without your assistance, we miss something.
My lord.
When we read without your assistance, we miss something. That's why. The
Page
dots-
69, my
the
lord.
dots could not be connected. That's why I'm asking that.
Yes.
69. Yes.
That the petitioner respectfully begs to state that Regulation 9(1) governs matter in which promotion has to be made to higher cadre and accordingly Appendix 2, Table 2 provides that all posts of assistant executive engineer are to be filled up by promotion, that is 100%. It further stipulates that one has to have 5 years in service in the feather cadre of assistant engineer for being eligible to be considered for promotion. Now, this is the line which they would like to harp, my lord. It categorically stipulates that one must possess the qualification of BE, BTech, AMI, etc., for being eligible for promotion. However, qualification shall be relaxed to diploma engineering in case of incumbents are or have been promoted in the feather cadre and not otherwise. Now they are, my lord, making the averments to suit their own requirement. They say in case of diploma holders, the degree can be relaxed, but the diploma holder must come to the feather cadre by your promotion, not otherwise. Am I clear, my lord? Now, what is their case? Please have the regulation for a moment, my lord. What they are relying upon is, my lord.
Just a
Yes.
moment.
Otherwise, my lord, the case is on a very narrow compass. Please come to Regulation 9. There is no dispute that we do not have a degree.
So basically promotion and upgradation.
My lord, in Delhi Judicial Service, exactly similar things happened. The High Court interfered, Supreme Court said no. I'll place the judgment. Please come to 9.2, my lord. They're banking their case on this Regulation 9.2. For recruitment to the cadre of assistant engineer in the board, the required qualification would be bachelor's degree in engineering, BTech, BE, BTech or BSc in engineering in chemical, civil or environmental from any recognized Indian or foreign university or AMA institution of India. The educational qualification and experience for other posts under this service shall be as per Table 2 in Appendix 2. Now, this is very important. Please come to page 33, Miller, of this.
Yes.
Please come to, my lord, Appendix 2, serial number 5.
Yes.
Assistant executive engineer, then, my lord, qualification is BE, BTech, etc. Pay scale is given. Then the feather cadre is assistant engineer. Then promotional avenue is assistant executive engineer. Then 100% by promotion. 5 years of service as A, which we have. Then please come to the last column remark. Do, meaning for existing promoting engineer, the qualification shall be relaxed to diploma in engineering. Now, I will respectfully submit, my lord. This has to include not only diploma in engineering, but also the upgraded ones. Otherwise, my lord, our upgradation makes no sense. And that is again pursuant to the policy decision of the central board, supported by the regulation which permits upgradation. My lord, upgradation is a, my lord, process which is not unknown in service jurisprudence, my lord. It all depends upon the administrative exigency as per the requirement. I'll place all the case laws on the point.
When there was a lot of issues with regard to labor issues that for their protection and all, there was a joke which was circulating. He said, now we don't call him a peon in the office. We have given him a designation of executive vice president to empty waste paper basket. So now he's an executive, not a laborer, and therefore doesn't come within the labor laws.
Correct. So, my lord, now my humble submission is, my lord, our upgradation to executive engineer, which took place in the year 2005, was never put to challenge. Now, my lord, my humble submission is, if I am upgraded to assistant engineer, then for what purpose? I must, my lord, might as well enjoy all the benefits flowing therefrom.
That's why we told you the joke.
Now, my lord, now let me place the facts, my
Yes.
lord, before I formulate my arguments. Then, my lord, I have already placed 147 whereby we are upgraded. Then, my lord,
Mr. Sinha, in this case, only notice was issued. Normally, it should have been the, what you call, it should have been admitted for hearing. We issue rule and admit it for hearing,
Which case, your lordship?
this matter.
Your lordship, it was in fact, this item number 1 was in the hearing, your lordship.
no,
No,
item
no,
number two,
item
two.
number 2 is still in the admission column. By an order dated 10/3,
Yes, your lordship.
only notice was issued. Normally in appeal, it has to be admitted. Notice is not a requirement. Now you agree to a date for hearing.
My lord, can I pray for my lord, 10th of February, my lord, or 12th of February?
Just check your date, tell Mr. Chaudhary.
12 তারিখ 12 তারিখ হওয়া পাৰিবা? Oh, কি আছে? 12th of February is a Thursday also, my lord.
There's no special bench on the date. Razi? No special bench.
দৰকাৰী লাভ নাই। এইবিলাক মই নকওঁ। ক্লায়েণ্টৰ লগত মই নকওঁ দেই। মই মোৰ মতে কেছ নকৰোঁ।
There's an interim order operating in the main,
There is.
first, in item number 1, there's an interim order operating.
Yes,
We,
in both the cases interim order operating.
both cases.
Your lordship, may I take it, not inconvenient of this honorable court, can it be taken up on 19th, your lordship?
I don't have an issue. You, both of you discuss.
হ'ব দে না?
Your lordship, I have never been-
মই আছো, মই আছো।
No, that's okay. It's not,
In the meantime,
hardcore.
there has been a development, your lordship, pending this case, they have been further promoted to higher post. That-
Not all, the one who are
There's a
promoted.
status quo already, the subject to outcome is already there.
Yes, yes.
Your lordship. But in spite of that, they have also filed an affidavit seeking leave of this court to further allow them to be promoted, which was not allowed. Yes.
I'll not do, that the board will do, I'm not board.
In fact, they have filed an affidavit, your lordship.
That's okay.
This is
we
on
have-
record.
আমি ফাইল করেছি। কি?
Because even with your submission, it doesn't appear that there would be a contempt that has to be put to challenge. So therefore we leave it there. Once there is a subject to.
No, my lord, there is no bar that way, but in any case, it will be subject to the outcome of the case.
No, the thought process is whether there is a contempt, whether we should really put our foot down. When it is no contempt, but it is a challengeable order, we leave it there.
Yes.
We don't make any observations right now.
In fact, your lordship, these promotions, they are on the interim management. So the honorable court has said that my seniority and their promotion will be subject to the outcome of the.
No, we don't know. We may be wrong, but please
In
tell us.
fact, my
You
lord,
see,
on
what happens
the,
is that when we pass orders.
he has also been promoted, now it boils down to seniority.
No, it's not that.
He has also been promoted.
No. You see, when we pass an order, we pass a very conscious order. We say that no promotion without leave of the court. Then leave is required. If you otherwise pass an order and it is put to challenge, notwithstanding that promotion is made, it would be an order which is open to challenge.
Actually, my lord, there is an order of the National Green Tribunal, my lord, where the cadre strength of each and every cadre has been increased. That is why, my lord, in administrative exigency, this promotion has been made. Whereas the present appellants in item number 1, my lord, they have not been promoted. Who have been promoted is the who were promoted. There are two categories. One is promoted, one is upgraded. The one who are upgraded, that is in item number 1, today's list, who have not been promoted. The one who are promoted, they have been promoted. In fact, my lord, the one who is promoted, this honorable court was on the verge of allowing that appeal. Only when the court found that those who were upgraded also tagged, that is why honorable court said you retag both the matters. That's why on
There
terms.
was- I disagree with what my respect senior said. There was nothing, no conclusion was ever came down from the court. What he's making is that there is nothing. Otherwise, the court would have allowed it. Why is making that submission, your lordship? In fact, your lordship, they have filed an additional affidavit. These appellants, 6 to 10. They said that they filed an affidavit on 4/9. And that.
My lord,
they break
my
from
lord,
action.
let me explain to my learned friend one thing, my lord. Those who were promoted from assistant executive engineer to assistant executive engineer, they were upgraded in 2005. That order is not challenged. Now subsequently they are promoted. So by virtue of that appendix 2, my lord, in any case they are member of the service. So that is why this honorable court was of the view. Don't argue for the sake of arguing, argue with substance. It is a very clear thing, my lord, those who are promoted.
It's
No, the
okay.
rule is reading in his favor. The rule says otherwise. your lord.
Mr. Rana Banks' argument on the fact that there is no order. Once there is no order and the.
Well, my learned friend was present on each and every date of hearing. This necessity arose because this honorable court division bench found that there are someone who were upgraded also. Might as well detect. The purpose is what?
Okay.
No, I'm not
In
disputing on
item
that.
1, you say both sides are presented in view of order passed in WA 12 of 2023. This is the matter for hearing on 19 to 2026. And in this item 12, second item, WA 12, you see. Well, Mr. K. Chaudhary, Learned Senior Counsel, assisted by Mr. S. Das, Learned Counsel for the appellants. Also heard. But State of Assam and others represented by you, including Principal Secretary Environment. Mr. Sharma will be there. So,
P.N. Goswami is a.
environmental, who appear for environment? Huh? I got a good. Sir, I got a good. Then standing also for the Environment and Forest Department, representing respondent number 1. And then the 1 and 2. Mr. S. Barwa, the standing also for Pollution Control Board, representing respondent number 3, 4, 5, 6. And Mr. R. Sinha, the council appearing for respondent numbers 7, 2,
Only 7 minutes.
only 7. Who's for 8? Joyanta Kuladhipati Nath, Yenudhar Takdar, who are they?
Huh?
Oh, no, then this is wrong. I'm noting from the first title of the writ petition. One and two, three, four, five,
Again,
six, 7 is Jagat Dekar.
Jagodeka is the read petition.
Respondent number 7. And who is for 8? The Raj Ardao.
My lord, he has not appeared before single judge also, my lord.
He has been made performer.
In fact, my lord, his analogy was brought in by way of an, my lord, illustration. So it may not be very relevant. Lordships can delete his name from the array of parties also.
In fact, your lordship, Vibraj was arrayed as a party responding to the writ petition.
No, no, not that. No, no, no. I must look at into whether the service is complete or not. Steps have been taken. I can just. If he has appeared, then it is.
No, he didn't appear before single judge also.
Okay, service is complete.
Yes.
So you want his name to be dropped.
Let it be there. If it is complete, let it be there. I thought if it is not complete, then in that case.
None appears on call. As per office note dated 23/2023, service is complete in respect of respondent number 8. Mr. Howard, none appears on call for respondent number 8. Next para. In view of the projection made in this appeal, the court is inclined to admit the appeal for hearing without requiring any fresh steps to be taken. Next para. List the matter for hearing on 19/2/2026.
Development.
Item 3 for admission.
May I please your lordship, for time being, my lord, my senior leg in another court number 14. Also.
Item 4 for orders.
My lord, this case has only been listed for orders. It ought to have been for admission. Sure.
Your affidavit has come on record.
My lord, wrongly, the appellate, I was not supposed to supply the copies of the photos. It was the respondent, my lord.
No,
They
no,
are
you
in
see,
their-
in the last order, we have said,
Yes,
the learned counsel for the respondent submitted that the photograph of the site has been annexed to the affidavit in opposition. However, the same is not a part of record. Now, the office note says no affidavit in opposition has been received by the section. We have not filed an affidavit.
On part of the jurisdiction that observed, that observation was that the previous record, the WPC record should be required, and that is in the record.
my lord, those photographs are in the record
In the record.
and record have already been issued.
Let's see.
Your lordship will see specifically the additional affidavit filed by the respondent. कितना तारीख क्या हुआ? ऊपर होगा यार.
So this is a wrong observation in the order 1612. Your affidavit being filed is an incorrect observation in the order.
Affidavit,
No,
I filed an affidavit in the written petition process.
In the writ
Yes.
petition.
And that
So this is wrong.
was not there on that day, but on the previous day. It's a part of the written petition.
Okay.
The additional affidavit which has been filed by the other side, no, affidavit in opposition which has been filed by the Other side, my lord, page 81 to 89 and 90 to 98. There were the photos, my lord. And the photos are specifically at page 86 of their affidavit. My lord, Monday most probably 26.
Oh.
20. Hmm. Much. Hello, let it be in admission column. Much.
Item 5 for hearing.
I mean, matter may be taken up after some time, Milord. In the meantime, I may be allowed to go through the record. Mukuri, all of us are controlling the delegate question. Record and and for imagine about the also. Corona, matagal yung kuha. Tumikote. Tumikote. Next, more all of us are going to sign up.
Item 9 for hearing.
My lord, in this case, my lord, the petitioner is suspected to be a foreigner and declared. My lord, whereas, my lord, the great grandfather of the petitioner was a Sipai in 1948. At the time of independence, my lord, that is I have exhibited in the trial court as well as before this honorable court also, my lord. That is at page number 24. Page number 24, exhibit 9, and name was Bodon Sheikh as a great grandfather, and sufficient link document with the grandfather, father, and the petitioner. But there are some discrepancy in the name of the petitioner and the father of the petitioner. That is why I have been disbelieved, my lord. When exhibit 9 is the great grandfather, the document of 1948, and page number 22 is the grandfather. My lord, I could not annex the written statement as well as the evidences, my lord, at the time of filing of the requisition, my lord. I think, my lord, the LCR has come. I could not obtain the certified copy, my lord, sir. Exhibited documents I have annexed.
But this, you see, unless the home department issues to all the administrative order to all the tribunals not to return without keeping true copies of the exhibits, you can't proceed in the matter now. The tribunal's records, the photocopies do not bear the signature. In the opinion, the tribunal refers to the documents. Yes. And the point which you are trying to ask you is that, you see, the pension payment order is 1948.
Yes, actually.
And this document you see, does not bear the signature of the issuing authority. And it is in the top, it is the deputy commissioner's copy.
Yes.
Now, deputy commissioner's copy can't be with the pensioner. It has to be a pensioner's copy. Otherwise, so far as I understand, the treasury will not give you money without the pensioner's copy. What does the document prove? We can't know now.
That is true, madam. In fact, madam, I have to admit these things, madam. These were done prior to madam now these are not accepted, madam, unless the original copy is not furnished. This cannot be accepted to the exhibitors because even there is no seal and signature of the Malad tribunal.
That's
So it cannot be accepted as Malad as exhibit. That is true, madam.
Mr. Ali, you will have to produce the original documents. Otherwise, we'll have to dismiss your appeal.
My lord.
The original documents are not here. Original documents you have taken back.
Pensioner original. Pensioner original. Pension.
My lord, I will produce.
Give you 2 weeks time.
My lord.
Produce the original.
My lord.
What says the representative? The travels records do not contain the original exhibited documents. Therefore, command the Mr. A.R.E. and counsel for the petitioner is directed to the A.R.E. and counsel for the petitioner is directed to inform the petitioner to produce the original original exhibited documents. Full stop. Next list on. 2/2/2026. Second of February. This is the original.
Original documents have been returned, madam.
That is why. That's why. This way. Is it there?
Yes,
Is it noted?
It is noted here.
Deputy of lawyers.
Item 10 for hearing.
Next, sir, one is the impugned final order lordship dated 6/12/2018 lords.
Page number? Page number?
Page 13 lords.
30.
1-3.
Yes.
May I read the order lords?
Which page is your written statement?
Written statement lordship, I have not annexed lordship, but evidence is there lords. Evidence of the petitioner, page 19 lords.
Do you have any voter list of you and your father together?
No, but the only thing that I could not exhibited those documents, Lordship. But subsequently in this petition, I have annexed, Lordship, such certain voter list, Lordship. Only a voter ID card was exhibited, Lordship. That is exhibit D, Lordship.
How do you connect yourself to your projected parents?
Lordship, one exhibit E, Lordship, page 28. So voter identity card, Lordship. Lordship, my name is Kurappan Ali. Executive as Kurban Ali, Lordship, and father's name reflected as Lordship, Talasan Ali, Lordship. Before that, Lordship, Annexa D is the voter identity card of the father of the petitioner, Lordship.
Oh. That's, you're not been able to connect yourself to your projected father and grandfather.
Not sure. Only thing is that.
Your grandfather is of a different, this projected grandfather is of a different village.
Not sure.
There is, you are from a different village. So except for the certified copy of voter list, there's nothing to connect your grandfather to your father.
Lordship. There is another lordship exhibit B, your lordship, kindly be produced lordship.
But it's a different village.
Lordship is certificate lordship. Certificate for the voter list of the year 1993 lordship for the father of the petitioner lordship.
Yes.
The certificate that Kurban Ali, that is a petitioner, and his father's name reflected as
But this is not even an evidence.
Lordship.
The reason is that this is not a certified copy of voter list.
No, that is right, Lordship. And the only thing is that I have categorically mentioned in this petition that Lordship, some vital documents I could not be produced, Lordship. If your Lordship allows me to submit those documents as exhibited before the Planet Tribunal, Lordship, then even though I have annexed those documents also, Lordship, in this petition, Lord.
Which are those documents?
Documents, Lordship, your Lordship can find it on page 47 to up to 58, Lordship.
What is your name?
In the petition, Lordship.
Yes, petitioner.
Lordship.
What is the name?
Kurban Ali, Lordship. His father's name Kalasan Ali and
How do you spell it? Kurban Ali?
Lordship.
How do you spell that name? Kurban Ali?
Kurban, Kurban, Lordship.
The India certificate is Kurpan.
Kurban, Lordship, Kurban,
But still you fail.
Lordship,
You see, the reason is that you buy an affidavit, you are saying that the name should be that.
Lordship.
Correct. Now come to page 44. In fact, page 45.
Lordship,
This is your ration card, I believe.
Lordship,
Here you have disclosed again your name as Kurpan.
Kurban, Lordship,
Both Kurpan.
Kurban, Lordship. This is right, Lordship.
Then you can't by affidavit change your name to somebody else. Because this family identity card is given at your own declaration.
Lordship,
This is not drawn from the voters list.
Lordship. But in the order itself, Lordship, in order, Lordship, the address of the petitioner and the voter ID card is the same, Lordship.
But these documents annexed.
Lordship.
Now these documents are an admissible document. Anmati Pradhan Patra, uncertain copy voters list.
These are all documents to include your name in the voter list.
In the kindly on the page 64, it's a 2012 voter list also. As first his name has been appeared, Lordship. Page 71. Here is also his name is appeared as Kurban, Lordship. But father's name is same and other family member name is also same, Lordship. Page 71, serial number 187. Third from the last, Lordship.
No, we are not being able to follow you. You see, you in your voters list, you say that you give a name of a particular village.
Lordship.
Now, when you are showing us page 79, it's of a different village.
Lordship, Lordship. These are the documents that I have exhibited, Lordship.
I understand better. Had it been a match, you would have understood.
Lordship.
You, these are what you call annual Khirat Pata, that is again in a different village.
No, Lordship.
Chaudhuri Para.
Lordship.
Sit down. There is no correct, in your written statement also, there is no correct showing of the, what they call the shifting or otherwise. There's no statement anyway. In your evidence also, it is not there.
Lordship. Then I'll leave it to Lordship.
Yes, Mr. Pai.
Yes. Two aspects with your my lord. First of all, my lord, the first of all, my lord, the petitioner could not establish himself to his projected father. Secondly, my lord, even the father has no link document, direct link document along with my lord projected grandfather. So, because the father's first document is 1993, my lord, one document of 1993. That is the first document of the father. And my lord, last document of projected grandfather is of 1970 in a different village. Now it was their duty, first duty was to, my lord, because the first documents they are relying is of the father is 1993 voter list. That will not help unless it is traced to, my lord, prior to 1971. So prior to 1971 is the projected grandfather's document. Now,
Only thing is that he's saying that voter identity card, right?
yes,
Not
link
that
document to the
connected.
father is to link his father, my lord, himself with
Yeah,
himself.
father and grandfather also.
Yes. No,
Page
that's why,
27.
yes, page 27. Now, my lord, first of all, he has to establish, my lord, that he is the grandson of Abdul Hamid Samer, who was there in 1966 at Sampura Pathar village. Because Sobananda Sonowal has clearly said, my lord, para 26, that he has to prove, my lord,
In the voter identity card also, that Hamid Ali, Abdul Hamid, two different persons.
my lord, discrepancies are there. Even the,
Hamid Ali, Abdul.
yes, total discrepancies is there. Name discrepancies are totally there, my lord. Now, my lord, even the, as Sobananda Sonowal has said, my lord, he has to establish even the citizenship of the grandparents and parents, if necessary. When it is necessary, if he cannot, my lord, produce any documents of himself prior to 1971, then my lord, he has to establish citizenship of his parents, that he was a citizen of India and was residing in India prior to 1971. If he cannot establish his parents, my lord, residence in India prior to 1971, then it will go back to, my lord, grandparents. So he has to link somehow to the grandparents here. So parents, father does not have any documents of prior to 1970. So he has to link somehow to the grandparent. But that link is not there. That is the point, my lord. First of all, father has to link himself to the grandparent. Then petitioner has to link himself to the father. Both the links, my lord, there is no document except this, my lord, the epic. In both cases, is trying to show himself is linked to the epic. And epic, there is, my lord, discrepancies of name, first of all. Secondly, it is settled position, my lord, epic. In one of the judgment, it is said by this noble court, epic is not a piece of documentary evidence to prove his citizenship, my lord. And it has to be proved. Epic has to be proved. That is the point here, my lord. So secondly, my lord, even in WS, neither in WS, no evidence I have seen. My lord, the father was 40 years in 1993. As per the voter list of 1993, he was 40 years in 1993. And he was supposed to be, my lord, eligible to cast vote in 1974. So 1974 onwards, the father was eligible to cast vote till 1993. And what happened to the grandfather after 1970, that is not known to us, my lord. That is not known to us. That is very important because if grandfather was alive, my lord, then father and grandfather would have been a common voter in a common voter list. But we cannot say what happened to the grandfather because that pleading is not there. If grandfather died after 1970 or prior to 1974, that would have been a different issue, man. But if grandfather was there, whether grandfather was alive or not, that is not disclosed.
Grandfather, see, in all the subsequently he submitted certain documents with their picture. Everywhere it's Hamid Ali. It is
Yes.
nobody called Abdul Hamid.
Yes. No, that is another issue, Malad. The discrepancies of name is totally
No,
is there.
It's not discrepancy.
Yes,
Mr.
yes, it's a totally different name, man.
Different name.
It's a different name, man.
Person altogether. This
Person
is-
altogether. Village is different, name is different, Malad. All different, all are different. That's why I'm saying. And secondly, the new documents, Malad. It will similar, as your lordship has rightly pointed out, the projected grandfather in 1966 is Abdul Hamid. And the epic, it is Hamid Ali. It's a different name. And the village is also different.
Lordship, I just point out one thing, Lordship, the only ground remains, Lordship, there is a grandmother, Lordship. I have categorically mentioned in my petition also that she is still, at the time of filing the petition also, she was living with the father of the petitioner, Lordship. And his name is their Lordship, her name is their Lordship. In the 1966, Lordship, her name is Kodvano.
He came to depose now.
No, Lordship. Oh, Lordship, that is right,
Different
Lordship.
village.
Lordship.
And we are trying to find out if there is a connect.
Lordship. Only thing that his Kadbanu Necha, Lordship, and the husband name Abdul Hamid. And in
Abdul
the
Hamid.
Lordship,
But now the problem
Hamid
is your
Ali.
own affidavits.
Lordship.
You have read your affidavit.
That is right, Lordship. But in the till 2016, Lordship, I have annexed the voter list, Lordship. Her name was there, Lordship. I have just checked, Lordship.
Because in your in your affidavit, you take a strange stand. That's
Oh, no.
the difficulty. In your one of your affidavits, you have said
No.
that so and so is my grandfather. I came to know about it from the documents.
Lordship. I know.
That is
The side point
taking
out
away your
is
credibility. You don't know you don't people will not know the grandfather by the document.
Lordship.
They will know it and then support it by a document.
That is right, Lordship.
So there lies your difficulty. Trying to find answers for you. Yeah.
Lordship.
And your father doesn't declare.
Lordship.
The name of his father is different.
That's right, Lordship.
In the evidence at DW2, read that, it doesn't say anything.
Abdul Hamid, Lordship. Hamid Ali.
How will a grandson come and say that my grandfather's name was wrong? He knows the grandfather by, you see, he knows the grandfather by documents.
Lordship.
Now, when the document says X, he can't come and depose and say the name is actual Y. Because this shows that he does not know his grandfather.
Yeah.
And second point is that when you say that your grandmother was alive till the filing of your the written statement and evidence, does it not look to be very strange that you don't know about the name of the grandfather through your grandmother? Here lies the problem.
Lordship.
Where is the which what do you call voters list you are trying to show with your grandfather? With your grandmother? Which was
2016 Lordship last.
where is that?
Page.
Which page?
I'm sorry. Page 75 Lordship.
75. Okay, which one?
Left side Lordship, third below Lordship. Kodbhanu Bidhava, Swami Nam Hamidan. Translated.
Which one? There are three columns. Which column?
Left side Lordship.
Left side.
Third from below Lordship.
First from below.
Third.
Third. Kadbhanu Vidhava. Another problem. This page 75, from where do you find the village name?
Lordship. Above Lordship, Bidhan Sabha Homosti Nam Polasbari. Village name is not there, Lord.
Not there.
Village name is there? Village name is not.
Come to page 70 of the registration.
70 Lord.
70. Your father was 65 years in October 2017. Now this is a photo list of 2016, saying your grandmother to be 80 years. That means your father would have been born when your mother was 14 years. Years to pregnancy in 13 years.
Lord.
Really believable. So we'll take a short break and come back.
So, my lord, my submission is that the petitioner has failed to establish his link along with parent as well as grandparent. And by no means he could establish any link to his projected grandparent. That is the main point. my lord. And secondly, my lord, he has submitted some documents before the Honorable Court. My lord, this is settled position of law in certiorari jurisdiction. This Honorable Court may not look into those documents because those were not part of the records in the tribunal. This is settled position of in numbers of judgment. Only one judgment I would like to refer, my lord. That is of this Honorable Court. In fact, it is in this, my lord, the Muslim Mandal itself in para 112 clearly say what is the jurisdiction of this Honorable Court. So that is clear. And one aspect, thereafter, this Honorable Court, my lord, in this judgment had state, only few lines I'd like to read out, my lord, with the citation. The petitioner have enclosed few documents with the writ petition for consideration. We would observe that fresh documents introduced in the present writ petition cannot be looked into or considered, the same not having been produced, exhibited or proved before the tribunal at the first instance. So this cannot be looked into here. This is a the writ petition is 4020/2017. WPC 4020/2017, my lord. Asia Khatun, ASIA, Asia Khatun, KACTWN. Asia Khatun disposed of on 21/11/2019.
20?
Yes, 21/11/2019 disposed. There is no para, but in the last part of the it's a small order. Secondly, with regard to the photo identity card, voter ID, that your lordship will find it. This is it. WPC 3547 of 2016.
Just a moment. WPC
3547 of 2016, my lord.
Yes.
Babul Islam party. Babul Islam decided on 9/5/2018. 09/05/2018.
What does it say?
Para 20.2, my lord. It is said, my lord, exhibit 7, the photo identity card is concerned. Besides not being proved, well, first of all, it has to be proved, my lord. Besides not being proved, it is a post 25/3/1971 document. Besides, merely producing such an identity card in absence of supporting evidence would not be proof of citizenship. And discrepancies of name, my lord. But here it is totally different name. But here it is para 23, my lord. Because by filing an affidavit, he is trying to say that the projected grandfather is different. Name is different.
Just a moment. Just a moment. Mr. Fukan, uh, this this page 78. This is in our copy, it is certified to be true. Correct. So we take it that this is a correct document. Presume it to be a correct document. Now, please come to first entry. Male Kalchan Ali. Name of the father is Hamed Ali. Mother's name is Rohima Khatun. She is not Kadhanu. Correct. And this is according to you, the complete NRC. Now come to serial number 9. Now there is one Kadhanu Nesa. Father's name is Mudadinu Sheikh. Mother's name is Rohima Begum. So that goes here. What? Had Mr. Arpakal Learned Counsel for the petitioner also heard so and so for the response. Next, by filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed give the name petitioner, namely so and so, has assailed the opinion dated 6/12/2018, passed by the page 13, passed by so and so, again tick marker, passed by so and so in FT case number so and so, arising out of it is in para 1, arising out of a reference. You can give REF reference column in Chanmari PS case number so and so. Thereby declaring the petitioner to be a foreigner of post. To be a foreigner by holding that the petitioner has miserably failed to discharge his burden to prove that he acquires citizenship of India by birth through genuine Indian parents. Next. The petitioner, upon receipt of notice of the proceedings appeared before the learned tribunal and filed his written statement on 7/4/2017, stating that he is the son of Mohammed MD, Mohammed Kalachan, 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 he has submitted voters list for the year 1966, where his grandfather's name appears as Abdul Abdul, Abdul Hamid Hamid, and grandmother, Kadbhanu Kadbhanu, Kadbhanu Nesa Nesa. Full stop. He has also submitted a voters list of 1993, where the name of his father appears as Kalachan, Kalachan, Ali. At village Bhatkua, Bhatkhuwa, next word Diya, Diya. So in the first one, that 1966, there you say the under village Sampupara, Sampupara. Then last, the petitioner has also submitted a copy of NRC legacy data, where his grandfather's name is recorded as Abdul Hamid, Abdul, Abdul Hamid. So the petitioner had also submitted elector, ELECTOR, elector photo identity card, within bracket, EPIC for short, of his projected father, and his own EPIC. EPIC is capital, EPIC. Full stop. He has projected that he is projected by swearing an affidavit and filed with the written statement that his name is wrongly recorded as Qurban, Qurban Ali, instead of Qurban Ali, Qurban Ali, and that his father's name is recorded as Kaluchan, Kaluchan Ali, instead of Kalachan, Kalachan Ali, and that his grandfather's name is recorded as Ahmed, Hamed, Ahmed Ali, and Abdul Hamid. Thereafter, on 5/5/2017, the petitioner had submitted his evidence on affidavit, and by reiterating the statements made in the written statement, had exhibited the hearing before referred documents as Exhibit A to Exhibit G. Exhibit, you can say EXT. Wherein Exhibit F and Exhibit G are the self-declaratory affidavits drawn by the petitioner. In support of his defense, the petitioner has also examined his projected father, Kalachan Ali, Kalachan Ali, as DW2. who has exhibited his identity card identity card. You see Epic, EPIC, Epic as exhibit H. And stating that he is living in village Bhatkhoa Dia, DhatKhoa, Dia Diya, and he is the father of the petitioner, whose correct name is Qurban Ali, Kurban. It is wrongly written in the epic of his son as Qurban, Kurban Ali. Further stating that both Qurban Ali and Qurban Ali are the same person. That's all. The petitioner is also examined. Next one is also examined one Waj OWAJ Uddin, a resident of village Kathalguri, KATHALGURI, as DW3, so the said witness is aged 72 years and knows the and claims to know the father, the projected grandfather of the petitioner, whose name appeared in the voters list of 1966. Further stating that is that it, that the that Abdul Hamid had a nickname of Hamid Ali. All the said all the three DWs, D and the smallest, were cross-examined and discharged. The next part, the learned tribunal on discussing the pleadings and evidence on record. The learned tribunal had had found all the exhibited document to be not acceptable for the purpose of proving that the petitioner has been able to establish his link between him and his father and the grandfather. And accordingly, it was held that the petitioner had failed to discharge his burden of proving that he has acquired citizenship of India by birth to genuine Indian parents. Next. The learned counsel for the petitioner, by referring to the documents appended to the writ petition, has submitted that the evidence of the petitioner as DW1 was discarded owing to discrepancies in the name of his name, his father's name and his grandfather's name. First off, it is submitted that apart from the documents which were annexed, which were exhibited before the learned tribunal, at the time of filing the present writ petition, the petitioner has provided further documents to show that there were documents with the petitioner to link him to his projected parents and grandparents. Accordingly, it is submitted that an opportunity be granted to the petitioner to prove the said documents by remanding the matter back to the learned tribunal. In the said context, it is also submitted that the name of the grandfather of the petitioner appeared in the land revenue records, being the Jamabandi of the year 1952, disclosing land at village Chaudhuri Para, Choudhurypara, Next para. Per contra, the learned standing counsel for the FT matters has submitted that the petitioner has not been able to connect himself with his projected father or grandfather. So it is also submitted that the the name of the projected grandfather of the petitioner appeared in the voters list of 1966. And after a long gap of nearly 27 years, the name of his father appears at the age of 40 years in the voters list of 1993. With stop. Thus, it is submitted that the name of the parents of the petitioner along with grandparents never appeared in any voters list to show the entire family together. By citing the case of Asia Khatun, ASIA, Asia Khatun versus Union of India, Mr. Payang, in these cases, if there are any cases which are reported, please try to connect those cases. I think Asia Khatun is a reported case. No, Asia is not. Huh? Yesterday we saw it, that Asia Khatun. Asia Khatun is not reported, right? No, I should. I'll see. No, it is not there. No, it is not there. This Asia Khatun, this is Union of India, KHATWN, Khatun versus Union of India, decided by WPC 4020 of 2017, decided by this court on 9/5/2018. Sorry, 21/11/2019. Lay emphasis on the point that a document which was not exhibited before the foreigners tribunal cannot be appreciated by this court. Moreover, by relying on the decision of this court in Babul, BABUL, Islam versus Union of India, WPC 3547/2016, decided on 9/5/2018. It is submitted that an EPIC, EPIC, being a post 25/3/1971 document, cannot be accepted as a proof of its contents without any supporting evidence. Accordingly, comment is submitted that the opinion of the learned tribunal does not warrant any interference by this court. Next panel. carefully considered the written statement and the evidence of DW1, DW1, DW2 and DW3, as well as the documents which are available in the writ petition, which are annexed to the writ petition. In the evidence on affidavit filed by DW1, is no positive statement regarding the name of his projected father and grandfather. However, what is stated in the evidence on affidavit is that the petitioner is submitting one certified copy of voters list of 1993. 1996, where the name of his grandfather is written as Abdul Hamid and name of his grandmother as Kadbhanu, KDPHANU, Nesa, NESA. And he is submitting a certified copy of voters list of the year 1993, where his father's name appears as Kalachan, Kalachan, Ali. In his cross-examination, the DW1 has stated that he came to know that late Abdul Hamid is his grandfather from the documents. Thus, though the petitioner projects existence of his grandmother till the year 2016, yet, the petitioner has no personal knowledge about the name of his grandfather. Full stop. The court takes notice of the ratio laid down in the case of Asia Khatun, ASIA, Khatun KHATWN within bracket Chopra, wherein the court is not required to appreciate the documents next to the writ petition, unless those are exhibited before the learned tribunal. Yet on a cursory perusal of Annexure 20 to the writ petition, which is a draft consolidated list for NRC within bracket 37/2018, bracket close. It is noted that against the name Kalachan, KALACHAN, Ali, the father's name is recorded as Hamed, HAMED, Hamed Ali, and mother's name as Rohima, RAHIMA, Rahima Khatun. and name of spouse is Coulson. Kulc Kulsan, Coulson Nessa, Nessa. You say within bracket. Rough translation from Assamese. Rough English translation from Assamese. Huh? So, whereas, comma, against the name appearing at serial number 9, which is Kadbhanu, Kadbhanu, Nessa, comma, her father's name is mentioned as Mudadinu, Muda, Muda, next word, Dinu, Sheikh, Sheikh, and mother's name is Rohima Begum. Full stop. Therefore, comma, the projection of the petitioner before the learned tribunal that his grandfather is Abdul Hamid and that his grandmother is Kadbhanu Nessa cannot be accepted at its face value, being contrary to the petitioner's own document annexed as Annexure 20 to the writ petition. Full stop. Moreover, comma, the voters list of 1966 within bracket Exhibit A, showing name of 2 voters, comma, have their place of residence at village Sampur, Sampupara, comma, Moja, Mouza, Moza dash Pub dash Samaria, Samaria, in the district of Kamrup. Whereas the names of voters appearing in the voters list of 1993 within bracket Exhibit D, bracket closed, are residents of village Bhatkwa, Bhatkuwa, Diya, comma, Moja, Mouza, South Horubar, Sarubar, in the district of Kamrup. Full stop. However, comma, in Annexure 20 to the writ petition, comma, the names of persons appearing there are residents of village Agumi, Aggumi, in the district of Kamrup. Oh no, the village, the name of the village is Magjumi. Village is Magjumi, Maggumi. Full stop. Next one. Therefore, comma, it appears that the petitioner has obtained a certified copy of the voters list of 1966 and he's trying to connect the said voters as his projected grandparents. which privacy cannot be accepted in view of the contents of Annexure 20 to the writ petition. Full stop. However, the court hastens to reiterate and reaffirm that the observations made by this court by referring to Annexure 20 to the writ petition has been done under unique facts and circumstances of this case. With no intention to disturb the ratio laid down in the case of Asiya Khatun, ASIA, AHATWN, within bracket Supra. So accordingly, the examination of Annexure 20 to the writ petition is under unique facts and circumstances of the case, not intending to be cited as a precedent in any future cases. Next one. The petitioner had examined his projected father as DW2. The they said DW2 apart from exhibiting his epic, did not say that did not make any positive statement that the name of his father has an alias of Hamed Ali, Hamed, Hamed Ali. And he does not support the contents of the two affidavits sworn by the petitioner as Exhibit F and G. Exhibit F and Exhibit G. Moreover, he does not disclose the name of his mother. Next, the DW3 has disclosed his age to be 72 years as on 30/11/2017. So therefore, he would be a voter in the year 1966. Being born in the year 1945. However, he has not proved his own existence in the voters list of 1966, along with the projected grandfather of the petitioner. It is therefore, comma, there is no document to show that the DW three, who's stated to be a resident of village Kathal, Kathalguri, Kathalguri, had cast his vote along with the grandfather of the petitioner in 1966 at village Sampupara, Sampupara. In this context, what will refer to the ratio laid down in the case of what is that evidence that oral evidence would not suffice? We asked you to give a list of those cases. Same. Okay. In this laid down the case of Asia Khatun, where this court has laid down that oral evidence would not be a substitute of proof of citizenship. So therefore, comma, the evidence of DW2 and DW3 does not it does not come to the assistance of the petitioner in any way. Next paragraph. Under the circumstances, as the petitioner has failed to demonstrate that he could be connected to the voters whose name appeared in the voters list of 1966 within bracket Exhibit A, comma, the petitioner has miserably failed to prove that he is a citizen of India and born out of bona fide citizens. Stop. Accordingly, comma, the opinion rendered, the EPN opinion rendered by the learned tribunal is not found to be vitiated by any error apparent on the face of record. But the opinion cannot be held to be perverse on account of consideration of extraneous materials on record. Extraneous materials or vitiated due to incorrect appreciation of the oral and documentary evidence filed in the case. Next, resultantly, comma, the challenge to the imperial opinion dated 6/12/2018, passed by so and so, page 13, passed by so and so. Bills, like resultantly, the litigation stands dismissed. Stop the consequences of the. No, in the earlier line, you write. In the earlier that the same earlier line, challenge to so and so is dismissed. Then you add the consequences of the said opinion shall follow. Next, resultantly, comma, this litigation stands dismissed. Next, by the registry should send back the records to the learned tribunal, along with a copy of this order to be made a part of record. We are sorry for the delay. We went to the bar to pay last respects to SR Rava.
Time being item 3 for admission.
Yes. 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 Which page is your written statement? 17. Yes. Is your speaker on?
Yes, Lordship, petitioner father name, Lordship appeared in the voter list of 1966, that is page 38, Lordship. And type book, yes, 30, 39, Lordship. Lordship, this is Azadul Haq, Lordship, and mother, this is her stepmother, Golastan Banu, Lordship. And
Yes, please continue.
yes, page 40 is the voter list of 1977, Lordship. Name continuing, Lordship, Adadul Haq, Gulistan Banu, Lordship. His father and stepmother. Same, Lordship, village. And then 42 is the voter list of 1997. And 44 is the voter list of 2008. And voter list of 2017 is page number 46.
But how do you connect yourself to the
Yes,
your
yes,
projected
Lordship, that is
father?
the question, Lordship. That is, Lordship, petitioner submitted, Lordship, two documents, and his father himself deposed before the tribunal that the petitioner is the daughter, petitioner is his daughter. The land document, Lordship, this is computerized draft Sita, page 54. This is a Miyadi Patta land. petitioner's name along with his other brother and sister's name were appeared, Lordship, as an co-partner, as a partner. This is page 54. Petitioner's serial number is page 14, and his father's name appeared in serial number 8. Page 54. 55 is containing name.
You see, your inquiry started in, what you call, long back, 1998, I believe. In 98, your inquiry began.
Yes.
This order of mutation, which you are referring to,
Lordship, only her name is not mutated. Along with his all brother and sisters, family members' name, same time it was mutated.
what are the dates of entry? It's not there.
Lordship, yes, in the manual Chita I have annexed, there is page 59. Page 59. This is manual Chita. In page 61, there is a remarks.
2019 हुकूमत होता है.
Yes.
Why a draft chitta? How does draft chitta prove anything?
Lordship.
How does draft chitta prove anything?
Yes, Lordship. Her name appeared along with his father. That shows a linkage.
No, but
She is the daughter.
What according to you is a draft? What is the validity of what is value of the evidence of a draft chitta?
Yes, Lordship.
What according to you is the value of evidence of a draft chitta?
Yes, Lordship.
What is it?
Lordship, he being the daughter of a person, his name is recorded as a inheritance, Lordship. By way of inheritance, his name entered in the Sita. And it is the order of the assistant settlement officer by which her name was included.
So that settlement operation, you see, this name came by way of a settlement operation.
Yes.
Settlement operation, somebody is found and the name is entered.
No, Lordship, it is Mohador 13/9/2019 or হুকুম মতে 4 নং স্থলত 18 পরা 17 নং নাম নথি সংশোধন করা হয়।
Who is the serial number 4?
Lordship.
Who is that serial number 4?
Yes.
Serial number 4 is
No, Lordship. Yes. No, serial, yes, serial number 4.
this is a
No. In column, that should be in ethanol status column. It is referring column, Lordship. Serial number 8 or pora 17, 8 to 17.
but it is in substitution.
Yes.
Correct.
Yes.
Substitution of number 4.
Yes.
Who is the number 4?
Yes. Yes, that is the grandfather of the petitioner.
But in your written statement, look at your statement.
Yes.
There's no date of death written. What is the last voters list in which your grandfather's name appeared?
Yes, Lordship. No, Lordship, from initial Lordship, his name recorded against her father, his grandfather name against her father.
So you see, after 66,
Yes,
the existence of your grandfather is not there.
Yes.
His existence is only in one voter list of 66.
yes.
After that, the existence of your grandfather is not there. Why would a mutation come in 2019?
No, Lordship 19, yes. No, Lordship, in same voter list are containing same person, Lordship. 1966, 1977.
77. Which page is that?
Yes, page 40. Adadul Haq, son of Asamtullah.
No. You're not getting us then.
Yes.
You're not
Lordship.
following us.
Nah, Lordship.
What is the name of your grandfather?
Yes, Lordship, this is Asamtullah.
Where is his name in which voters list is his name?
No, Lordship is voter list here I have not annexed because from 66 his father name appeared. So Lordship
Correct.
is used to put on directly his
Therefore-
father, linkage
therefore-
with his father.
Therefore, the existence of your grandfather is not there in the voters list.
Yes,
Correct.
yes.
Now, why would a mutation come in 2019?
Because Lordship, this father desires to give the land because at that time also he was 83 years. The father is above 70 years.
No, you see, you are projecting what is your projected case?
Yes,
That in lieu of respondent number, in list of serial number 4,
yes,
the other names were mutated. That means your father's name is also mutated by the same order. In 2019,
yes,
that's why we are asking you.
yes.
Your
No,
grandfather's existence is not there in 66. Why a mutation in 2019 after the inquiry in 1998?
Lordship, because only her name is not mutated. All the family members, Lordship.
But it's a chitha only.
Lordship. And Lordship, there is a Panchayat certificate, Lordship, which is also not.
No, more interesting than that is your father's evidence.
Yes,
Read out loudly.
yes,
Your father's cross-examination.
yes.
Read
Yes,
loudly.
yes, Lordship.
Which page is that?
Yes. 51.
51.
Yes.
Read loudly.
Yes. I know the OP who is my own daughter. That she was born at Zhokratsar in my house. She is aged about 42 years, but I can't say the date of birth. I have forgot the name of husband of my said daughter. What is the name of mother of OP? I forgot the same. I married 3 times in life. They are Gulistan Banu, Fatima. Remaining one is I forget. Gulistan Bibi is not own mother of Ofi. Now I remember that the Osefa is the name of Ofi's mother. I have 5 sisters and 2 brothers. When did I give my portion of land to my said daughter along with her brothers and sisters? I don't know. Lordship, kindly see the age of the person. He is 83 years old.
No, she's your witness. Ultimately, the
Yes.
witness is your witness.
Because Lordship, the father himself came before the tribunal and said, she is my daughter, Lordship.
Incidentally,
Lordship,
when a renowned lawyer in Delhi was 92 years, I had briefed him.
Yeah. Lordship, particularly, Lordship, this proceeding is concerned, Lordship, a 82 years retired person who goes to tribunal for divorce for his own daughter.
You see, these are very relevant. You say that you gifted your land,
Yes,
but under Mohammedan law, you can't give the land unless it is yours. What you call, you don't have a right of gifting properties which is not yours
yeah,
under the Mohammedan law, correct?
yes,
You must have the title and possession.
yes,
That's the first requirement of a hiba. Correct?
yes,
Now you don't know the date on which you gifted the land to your daughter.
because of Lordship, it is for old age.
Correct? It is relevant. That's why we are saying
No, definitely.
things which are otherwise irrelevant may be relevant under the facts and circumstances of the case. Now, your own name was mutated in 2019.
Yes,
Before that, contingent interest could not have been gifted.
so
Your daughter's name
Lordship,
could not have been there in your land records unless you got title.
then Lordship, one sponsor certificate, he also, Lordship, for establishing linkage. Otherwise, Lordship, his father name appeared in the voter list of 1966, and he himself deposed before the tribunal. And also, Lordship,
To state the overall constitution, the president of the United States. You get it in the internet, who is the president of the United States. Can I say that I understand?
no, Lordship,
Political possessing his name to be provide emails. The internet paying Can I get the land itself?
no, that is Lordship, different aspect, Lordship, because in the Lordship, tribunal proceeding, Lordship, no one can, Lordship, give his evidence that claiming he is my, normally, Lordship,
That example. I'm repeating him perhaps for
and then, Lordship, I'm sorry, Lordship, for that argument. Okay, Lordship. Okay, Lordship.
Delhi, there's a BMW.
Yes.
That BMW murder case. Shakti, after the owner was arrested, driver came and said that I was right. This other evidence is false. I was driving, I think, this evidence could be. Member of the blockade.
No, okay, Lordship, I will. Yes, Lordship, there's a sponsor certificate, page 47, Lordship, page 47.
He has been cross-examined.
Lordship,
He has been cross-examined.
sponsor, yes, yes.
I think it's a long page. There's going to say 40 from the page.
Yes. Also,
See, I've not found the certificate book as well as register for every day. I only got a card copy.
yes. Lordship, it was countersigned by the video, Lordship. Lordship, yes, Lordship, but in cross-examination, perhaps, Lordship, I don't know what had happened, but it was genuinely issued, Lordship, by countersigned by the video. There is a signature, mobile number, everything is there.
See. The document. Having the signature of the doctor. 5, 7, 8.
Yes.
That's always dependent of the video. Yes. We forget the name is further.
Okay.
The author certificate is not there. The name of the mother still it is only the photo is from 1977.
Yeah. Nineteen 97. What? Yes, Lordship, that is correct, but there's a written statement. His mother already expired while she was aged about 6 years. Yes, correct. Yes.
In your statement, in your evidence on affidavit,
Yes.
you don't give your age. Your age only recorded process at 41 years, is on 2022.
Yeah.
Your year of birth is 1980.
Yes.
But after 1977, your mother is not there.
Yes, this is the discrepancy of age. Yes, from the fact, no,
Here in that I remember the mother.
yeah,
Then it says that I remember that the mother is Josefa Vela.
yes,
Josefa is 1977.
yes, Lordship.
Neither there earlier nor there after.
Yes. But there is a statement that she died immediately after Lordship giving her birth, only 6 years, while the petitioner was 6 years old. She already expired. Yes.
I will be 82, 85,
Yeah.
then 73.
Yeah.
You see, there's a difference. Your mother, your circumstance says that her mother is police star.
Yeah, Lordship, that is only in cross, I have seen, that is only in cross examination. But in the cross examination, petitioner has not put to question who is your actual mother.
But ultimately nothing. It is what it was unnecessary excessive.
Yes, but in her written statement, evidence is consistent.
The logic is that the cross-examination is a unnecessary wastage of time.
No, Lordship, I'm not saying that.
That is only cross-examination.
No, Lordship, my condition is that because there is not single whisper about the question, who is her actual mother. Normally, who lives, no, Lordship, that is not my contention, Lordship. That is my Lordship humble submission, Lordship.
Perhaps at one point of time, you may pass a direction that is henceforth in all the cross-examination all across the country.
No, Lordship, that is not, no, Lordship, that is not my Lordship actual view, Lordship.
You say, who would know that who is the mother? Your knowledge is an acquired knowledge.
Yes,
Your knowledge of your mother is an acquired knowledge.
yes, definitely,
I don't know who has given me birth.
yes.
People around me tell me that she is your mother. He is your father. You did not see the birth. Therefore, you don't have personal knowledge. Your father comes and says, X is your mother. And you say that Y is my mother. Who has a better knowledge?
No, definitely, Lordship, because of Lordship, some illiteracy, Lordship.
No,
it
no, no, no.
happened.
You see,
Otherwise-
even illiterate people, they would know who is the mother. Mother is someone you can't forget.
Lordship, that is why, Lordship, I'm saying that he is consistent with his written statement evidence, but perhaps, Lordship, in cross-examination,
This will only happen when you find out documents, then pick up someone as your father, as your mother, and then make out a case.
no, Lordship, that in this presentation.
Then your family members do not know who is your father, who is your mother.
No, Lordship, his father 80 years old. Lordship, he also in his
I have
statement,
told you,
83.
I have told you. With great respect, I am again telling the name, telling you the same fact. At the age of 92, I had, when the senior counsel was 92 years of age, I had briefed him when I was standing in your place. There's no, you see, we can't take a judicial notice of the fact that once a person is 80, he would have no memory. Because I have met people who are more than 100 and they are
People have
pretty
different
good.
Lordship situation. It is happens due to physical condition, health condition. That is, I'm not denying.
One of my own relation is 96 years of age. I speak to her daily. Last year, she had come from Bombay alone to visit us. So therefore, I can't take a presumption of 80 plus not being able to answer. He
Lordship,
came as witness, he is expected to answer.
no, definitely, Lordship, as per procedure, I know, but Lordship, sometimes it happens.
Okay, let us accept your statement that 81 may make mistakes.
Yes.
Correct. Now, according to you, at the age of 40, 45, will the person make the mistake?
No, logically it is not, he is young person, he may not.
May not. Okay. Come to page 26.
Yes, sir.
This is the evidence on affidavit.
Yes, sir.
You turn on page to 27.
Yes.
Page 27, paragraph 7.
Yes, sir.
I beg to state that I am the daughter of so-and-so and mother is Josefa Khatun.
Yes.
Correct?
Yes.
Now come to page 49.
Yes.
Just the second paragraph last. My mother's name is Gulistan Banu.
Yes, Lordship, in this I am firstly admitted in the chorus examination, he stated that I have admitted that. Then also fix the matter for hearing, final hearing.
Now we are hearing it.
No, Lordship, kindly, because I
No,
am,
we have heard it. That's all. There is no further hearing.
no, because
Because
I
I
am
will
not,
not retain I don't, you see, I don't have a retentive memory. After 1 hour, I'll forget everything.
no, Lordship, because the order.
You were referring to 90 years age, one may make a mistake. I am not in a 90 age group, but I will still make a mistake. After 1 hour, I'll forget everything.
No, Lordship, because the order, Lordship, for consideration my interim bail for today, Lordship, after receipt of tribunal for
We have done
consideration
it.
of bail, Lordship, because,
35 minutes now.
no, Lordship, because I am not fully prepared for final hearing.
That is your problem.
Yes.
It's not our problem.
Lordship,
You should not have taken the stand at all.
how to accommodate?
35 minutes is okay. Good enough. Nothing much you can do.
Lordship, can
You see,
one opportunity, Lordship, I.
We can't say anything. We have heard you.
Yeah.
That's all.
No, definitely as well, but because Lordship, my problem is that Lordship, I have to place some.
You
citation
see,
also, Lordship.
you are a learned counsel.
Yes.
Who told you to stand up in the court and start arguing without being prepared?
No,
Did we
Lordship.
force you to argue?
Mm.
Did we put a gunman behind you and said
No,
that if you
Lordship.
don't argue, we'll
No,
shoot you
Lordship.
down?
It is not like that, Lordship,
Is the
because
police available here that if you don't argue, you will go to jail directly from here? No.
Lordship,
So you had voluntarily started your argument.
yes, Lordship, because only for initially only for consideration my bail, Lordship. Lordship, for final hearing, Lordship, I have to make some preparation.
Don't
Lordship.
presume, because we said that we'll hear your interim order only after records are received.
Yes.
We don't spend 35 minutes for a bail application.
Lordship, can we short accommodation, Lordship, for the interest of justice, because I have to place Lordship some citations also, Lordship, regarding in
No,
support of
that's
my
over.
case.
Your time is gone. 35 minutes is good enough. We are not giving you more time. Sorry. You want to take an adjournment, take it at the first blush. We may might but we'll grant you that time. Not at the stage after 35 minutes. 37 now. Yes, Mr. Payan.
My lord, as your lordship has already pointed out, my lord, only I would like to point out one thing, my lord. The certificate issued by the government secretary, my lord, that cannot be accepted as that was only for the purpose of, my lord, allowed by the Supreme Court only for the purpose of sifting, my lord, not for linking with any other, my lord. Not for linking or to prove his citizenship or her citizenship, man. That was only allowed for the, my lord, to certify that the lady has been shifted from one place to another after getting married. For that purpose, and that issue, my lord, that has to be, again, the certificate has to be proved in two, my lord, ways. First of all, the authenticity of the documents itself and the authenticity of the contents of the document. And the second part, my lord, it has to be in a process, my lord, letter process, what the Honorable Apex Court says in that case. The letter process of verification is bound to be an exhaustive process in the court. My lord, the Rupjan Begum. Rupajan Begum. That is 2019. 2018 1 SCC, my lord, 579. Mm-hmm. 2018 1 SCC 579.
2019?
18 man, 1 18 1 SCC 579. Para 15 and 16 man.
Yes.
Para 15 says, my lord, the certificate issued by the GP secretary merely acknowledges the shifting of residence of a married woman from one village to another. The said certificate by itself and by no means establish any claim of citizenship of the holder of the certificate. So it is only to acknowledge the shifting of the lady, my lord, after getting married from one place to another only. And to even to establish that fact, my lord, that certificate has to be, how is it to be proved? That is in para 16, my lord. The certificate issued by the GP secretary by no means is proof of citizenship. Such proof will come only if the link between the claimant and the legacy person who has been citizen is established. That has to be established separately, madam. The certificate has to be verified in 2 stages. How it is, madam? The first in the authenticity of the certificate itself. The first, madam, authenticity of the certificate has to be, madam, verified and proved. And the second is the authenticity of the contents thereof. Now it says, my lord, the later process of verification, that is, my lord, the authenticity of the contents. The later process of verification is bound to be an exhaustive process in the course of which the source of information of the facts and all other details recorded in the certificate will be ascertained after giving an opportunity to the holder of the certificate. So the issuance authority here, my lord, the government secretary who came, he said he don't have any records at all. He don't know how the certificate was issued. Simply there was an application. The earlier, my lord, the secretary had issued the certificate. That's all. Even he doesn't know, my lord, he has not identified the signature of the video, my lord. He has said, I don't know the signature of the. So the certificate is nothing. And another that, as your lordship has seen, my lord, the contradiction in the, my lord, evidence between the projected father and the petitioner. It shows, my lord, the entire facts. It shows the entire facts. And thirdly, my lord, the CITA, which is, my lord, the draft CITA only. And that has been, my lord, prepared only 2019. And that is, my lord, it is also, even though we accept that there is a CITA, my lord, it's a land, but it doesn't show that it is the, my lord, she got the land by way of inheritance.
No, because we can't accept even that. You'll have to, what you call,
Yes.
unwind and wind me with the relevant law, because you see, a draft CITA by nature of the document is only a draft.
Yes, my lord, it is nature of draft, my lord. That's why I'm saying, like,
If it's a draft, then after a draft CITA, a final CITA is prepared. After
Prepared.
final CITA, it
The-
becomes a draft Jamabandi.
Jamabandi,
After draft Jamabandi, it is
it's
a final
final
Jamabandi.
Jamabandi, that-
Final Jamabandi is called to be a revenue record.
revenue record. That is,
Draft CITA is not.
that
It's
is,
a
that,
secondary evidence. It's
that is one, even though, my lord, if we accept, my lord, for the argument's sake, if we accept that also, it's a draft CITA and her name has been admitted. How it has got? By way of gift, my lord. She has admitted. Gift, definitely it is, my lord, as your lordship has rightly pointed out, my lord. See, he cannot gift the property unless he has the, my lord, ownership right. Now, even though it is gifted, gift is not by means of inheritance, my lord. Had it been by means of inheritance, my lord, that yes, he could claim that, she could claim that, yes, I'm the daughter of so-and-so. I may give the property to someone else. I may give to, my lord, some other person also. She may not be my daughter also. So gift doesn't show that she is the, my lord, daughter of that person who gifted the property. Had it been by way of inheritance, well, there are at least some, well, though the entire process is, my lord, not proper, then we could say, yes, at least there is, my lord, inheritance. That we could say, my lord, but it is by way of gift only. That is, my lord, in addition to other aspects, my lord. So the tribunal has committed no wrong in this entire opinion, my lord. So my humble submission is, my lord, the opinion of the tribunal may not be interfered by this noble.
Anything in reply, Mr. Ahmed?
Also, my humble request only, Lordship, for final hearing.
No, no, we are sorry, we have read it. That's bail, we don't give 35 minutes. No, 50 matter. At least in FT matters in this bench, you don't have any, even to argue for bail. If you can demonstrate by one document, we are very liberal in granting bail. Heard, is that Ahmed, learned counsel for the petitioner? Also heard, so for the respondents. Next paragraph. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the opinion dated page 71. A common opinion dated passed in, there are two cases, number one, number two. Arising out of, there are two IMDT cases. Take from here. Here you say this, case number 585 of 18 arises out of R oblique IM within bracket D, bracket close T, case number 252/98, and the other reference, other case is 256 of 2018, which has reference IM within bracket D, bracket close T, case number 7619/D/99. Yeah, but I'm corresponding to, second one, corresponding to R oblique IMDT oblique case number 1054/98. By the said opinion, the petitioner was declared to be a foreigner who has entered illegally into India within bracket Assam on or after 25/3/1971. Next. On receipt of notice of the proceedings, the petitioner had filed written statement in the in FT case number 585/2018 amalgamated with FT case number 256 of 2018. Amongst others, claiming that she is the daughter of Azadul, ADADUL, HOQE, alias Azadul, AZADUL, Azadul Haq, HOQE, within bracket father, and Osefa, OSEFA, Osef Khatun, KHATUN, within bracket mother, and granddaughter of Asmatullah, ASMATULLAH, one word. It's, you give a semicolon. Then her grandfather had two sons, namely Adadul Haq and Gyasul, GIYASUL, Gyasul Haq, semicolon. Her father has three wives, namely, Gulistan, GULESTHAN, Banu, Osefa, OSEFA, Osefa Khatun, and Fatima Khatun, FATEMA, Puchpa. She has 8 brothers and semicolon. She has 8 brothers and sisters, namely, so page 18. Like page 18. Para 9. At para 10 also. Again, semicolon. She was, in the year 1995, she was married to Noor Anwar, along ALOM, and shifted to her matrimonial home at Sahapara, SAHAPARA, under Mankachar police station, under the Pashpal Dhubri district. And after a year, her husband shifted his residence to Kaloghat, KALOGHAT, under Thakuran Bari, THAKURANBARI, Gaon Panchayat. On their inherited land. And since then, they are living there. Same, she is blessed with 5 sons and daughters. Full stop. The petitioner claims that the name of her father is recorded in the electoral roll of 1960. And in 1966, the name of his father is recorded along with her stepmother, Gulistan Banu, and her paternal uncle, Gyasul Haq, GIYASUL. The name of her father appears in the electoral roll of 1977, along with her above named stepmother, as well as Osefa Khatun, her own mother. He shows this There are two electoral roll of 1977. Which are they? Which page?
Lordship. 1977, page 40, Lordship.
40, but there are two. In page 20, you are referring to 1997. Where is the other one?
Lordship. One is 97, Lordship.
Oh, I'm sorry, 97. I made a mistake. 97. The name of his father, okay, is Electoral of 1997. Along with petitioner's other stepmother, namely Fatima Khatun. The father also has an EPIC PPIC issued by the Electoral Registration Officer. In 1997 and 2017. Then this EPIC. The petitioner is also referred to certificate issued by the certificate dated 5/7/2015, issued by the Secretary, Chogra Char, JHOGRARCHAR, Gram Panchayat. To refer to our inheritance of land, the petitioner has relied on the copy of Chitha, electronic as well as manual, and a landholding certificate. The petitioner also claims that the names Afruza AFRUJA, Afruza Begum, Afruza AFRUZA, Afruza Begum, and Afruza AFRUZA, Khatun are her name. And that her grandfather used to write his name as Asmat AXMAT Ullah, next word. But in the electoral roll of 1966 and 1977, his name is recorded as Asmat Ullah, one word. AXMATUL. Similarly, the names his father appears as Atatul ADADUL, Atatul Haq HOQE, as well as Azadul AZADUL Haq. Not explained that stepmother, Gulistan Banu, is known by three aliases. And her husband is also named, known under three aliases. Next, in support of her defense, the petitioner has examined herself as DW1. And she has also examined her father as DW2. And the lot mandal of Mankachar circle was examined as DW3. And where is that evidence of the Gram Panchayat?
Yes, Lordship. Page 48.
And one approved ABDUR approved Hafizur HAFIZUR Rahman, Secretary of Gograd Char JOGRHRCHR Gaon Panchayat DW4. Next, additional comment by reiterating the statement made in the written statement. Has exhibited the following documents. Take it from page 74. Also, all the set four witnesses were cross-examined and discharged. Full stop. Next, by the learned tribunal, after appreciating the pleadings and evidence, found that the linked document of the petitioner to connect her to her projected father, where the Gaon Panchayat certificate dated 5/7/2015, in bracket Exhibit 8, certified copy of manual chitta, in bracket Exhibit 9, and computerized chitta copy, in bracket Exhibit 10, and the holding certificate, land holding certificate dated 10/5/2012, as Exhibit 11. Insofar as it is concerned, the said it will go that stated that he has no personal knowledge about the petitioner, as he did not issue the certificate. He further disclosed that he has not found the certificate book as well as registered book of Exhibit 8, and that the said certificate was issued on the basis of application dated 6/7/2015 by Adadul 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 Haq. And that he could not identify the signature of the video. Block development officer appearing in the said certificate. In respect of Exhibit 9, 10, and 11, TW3 in his cross-examination. TW3 in its cross-examination stated that Exhibit 16 was prepared after 1980 and the name of Asmatullah, ASMOT, Asmatullah, Kopatadar number 4 was recorded in the Chitta, but there was no remarks regarding his entry in the records of right, and no mutation case was registered. And it is also not mentioned as to whether the names of Kopatadar from serial number 8 to 17 have been recorded as per law of inheritance or other means. He had also stated that the mutation was done on mutation of the name of the petitioner was done on 13/8/2019. And it could not say how the name of the petitioner was recorded as one of the Patadars. And that there is no note in respect of inclusion of their entry. Accordingly, the court did not find the learned tribunal could not find the link of the petitioner with projected father on the basis of Exhibit 9, Exhibit 10 and Exhibit 11. And those documents were held as untrustworthy and not acceptable. In respect of the electoral rolls, which were exhibited as exhibit numbers 1, PO2, 5, and 7, Learned Tribunal has recorded a finding to the effect that Exhibit 4, 5, and 7 discloses the name of the protected father as well as two protected stepmother. And accordingly arrived at a conclusion that said documents do not show any linkage of the petitioner with the projected father. The epic within bracket Exhibit 6 discarded being not proved in accordance with law. The learned tribunal reported the exposures made by the DW2 in his cross-examination. And as several contradictions came out of the cross-examination, including the including the identity of the mother of the petitioner remaining unsolved, comma, the evidence of DW2 was found to be insufficient and not trustworthy to prove that the petitioner is a citizen of India or that she is the daughter of Adadul of ADADU. Learned tribunal held that the petitioner was unable to discharge her burden to prove that she is born out of genuine Indian parent and has acquired citizenship of India by birth. This is definitely complex. Reference case was disclosed on by answering the reference in the affirmative and declaring the petitioners to be a foreigner of 2029. Next. The learned counsel for the petitioner has referred to the documents annexed to the petition, project that the evidence of the petitioner was discarded, clearly because of some discrepancy in the name of the petitioner's projected father and mother, ignoring the evidence on record. It is submitted that the petitioner and her father being illiterate, and that the father of the petitioner being a senior citizen of more than 53 years, might have made some inadvertent mistake in answering the queries put to them. Yet, the evidence of the petitioner remains untaken, so that is the daughter of Adadul Haq and granddaughter of Asmatullah. ESM. Okay. Mr. Ahmed, since you made a statement, we are asking you. Yes. You want us to record that you made a statement that you are not prepared and therefore wanted only to argue the bail parts.
Yes.
Should we record it in the order?
Lordship, I leave your lordship.
Hmm?
I leave your lordship.
No. You see, since you are a counsel,
No,
you
lordship,
shouldn't
basically
allow
lordship,
the court thinking
bona fide
that
lordship,
you were
I
treated unfairly.
yes, lordship, because I'm not prepared for final hearing. Lordship.
No, that's why we are asking you
Yes.
whether you want this to be recorded, because we don't want you to go outside and think by thinking that you have been treated unfairly.
No, lordship, surely lordship, because actually this order reflects that on receipt of the tribunal's record, the interim bail
No,
may
the
be
question is
considered.
whether you want us to record that or not.
Lordship, kindly record it.
Okay. It may be stated, that after the hearing proceeded for about 35 minutes, the learned counsel for the petitioner had made a submission to adjourn to fix the matter for a final hearing on another date, as he was not fully prepared. And he was only prepared to argue on the prayer for interim bail for the petitioner. Full stop. However, as the court has already spent more than 35 minutes of time, about 35 minutes of time in hearing the learned counsel for the petitioner, comma, the said prayer was rejected and the court proceeded to hear the matter. Comma, more so because in course of submissions, comma, the learned counsel for the petitioner had entered into the merit and had referred to all the documents which were exhibited by the petitioner before the learned tribunal. To stop. Therefore, comma, having spent a considerable time in hearing the matter, comma, the prayer for adjournment or deferment of the hearing to another date was refused, and the court has proceeded to hear and dispose of the matter on merit. Next paragraph. In the present case in hand, you just say per contra, comma, the learned standing counsel for the FT matters has opposed any interference with the impugn opinion and has made his submissions in support of the impugn opinion, and in connection with the proof of the documents and contents, specifically with regard to the Gram Panchayat certificate, comma, the learned standing counsel for the FT matters has referred to the case of Rupajan Begum, RUPAJAN Begum versus State of Assam and others, comma, within bracket 2018, bracket close 1 SCC 579. Full stop. It is submitted that the said in the said case, comma, the Supreme Court of India had laid down the law to the effect that the Gram Panchayat certificate was only to establish shifting of a married woman to the place of residence of a husband. Full stop. However, comma, it has been made clear that the said document is not a proof of citizenship, and that in order to prove the said certificate, comma, it was the onus on part of the petitioner to prove the authenticity of the certificate as well as the authenticity of the contents of the certificate. Full stop. Accordingly, comma, it is submitted that as the Gram Panchayat certificate was not proved by bringing the original records, and that the gift of land was not proved in accordance with law, comma, there was no merit in the defense of the petitioner. Next paragraph. In the present case in hand, comma, in a cross-examination, comma, the petitioner has stated that she has not submitted any documents in her name to defend the case, and she has submitted the land documents and the panchayat document in the name of her father. She has stated that her father had applied for a panchayat certificate, but she does not know when the same was procured from the office. She has restated that the name of her mother is Gulistan Banu, and that mother has 7 sons and daughters, and that Fatima Khatun is her stepmother who has only one son. However, to the to the however, contrary to the stand taken by the DW1 in a evidence on affidavit, written statement as well as cross-examination, the projected father of the petitioner, appearing as DW2, has made a positive statement that Gulistan Bibi is not the own mother of the petitioner, and that Osefa, OSEPHA, is the name of the mother of the petitioner. Full stop. He has stated that he does not remember when he gifted his portion of land to his daughter along with her brothers and sisters. Full stop. Thus, if the projected father of the petitioner has gifted his portion of land to the petitioner, the in the absence of any entry in the chitta, it cannot be said that the father of the petitioner had title over the land during the time of gift, as the gift is an unregistered gift. And in the absence of any entry as to the date of gift and the date of gift, the entries made in the chitta, in the opinion of the court, would not confer, would not prove or establish that the petitioner is the daughter of of Adadul Haq, DW2. Full stop. The DW2, who is the father of the petitioner, has categorically stated that, in his cross-examination that Gulistan Bibi is not the own mother of the petitioner, but her mother is Osefa. Full stop. The evidence of the petitioner to the effect that her mother is Osefa, is Gulistan Bibi, would be contrary to that of a projected father. Full stop. It is hard to believe that a father would forget who had given birth to to his daughter. Full stop. It may be mentioned that initially in the cross-examination, DW2 had forgotten who was the mother of the petitioner, but in course of cross-examination, he remembered that Osefa is the mother of the petitioner. Full stop. Therefore, Firstly, the land which has been recorded in the name of the petitioner in the draft chitta was not by way of inheritance and therefore does not prove that the petitioner is the daughter of a projected father, of the person projected as a father. Full stop. Insofar as the evidence of DW3 is concerned, who is the lot mandal, comma, while discussing the while referring to the imperial opinion herein before, comma, it has been mentioned that there was no remarks of any entry in the records of right with regard to the Upatada number 4, comma, namely, comma, Asmat PS MOT Ullah. Therefore, comma, there is a disruption in the link of the petitioner with her projected grandfather. Full stop. The said DW3 has categorically stated that there is no mention as to whether the names of Upatada number 8 to 17 has been recorded as per law of inheritance. Full stop. Therefore, comma, on the date when the order of mutation was passed and recorded in the chitta, comma, the father of the petitioner did not have an existing right over the land, but when in the cross-examination, the DW2 has stated that he had gifted his portion of the land to his daughter, comma, on the date when the order was passed, comma, the petitioner, the projected father of the petitioner merely had a contingent right over the land. Full stop. However, comma, the court would hasten to add that the court is not deciding on the issue of right title in interest of the petitioner over the land in question. Full stop. The discussion is only limited to show as to whether, to find out as to whether the petitioner has been able to link herself with a projected father and grandfather. Full stop. It is in this regard that the court is inclined to hold that the petitioner has failed to establish the same. Full stop. Next, insofar as the evidence of DW4 is concerned, comma, in his cross-examination, comma, he had categorically stated that he did not find the certificate book as well as registered book of Exhibit 8. Stop. Therefore, comma, the certificate within bracket Exhibit 8, the GP certificate, is found to be not proved in accordance with law, comma, which is by production of the original record. Stop. Moreover, comma, the said witness could not identify the signature appearing in the said certificate. Next. Resultantly, comma, owing to the discrepancy in the name of the mother of the petitioner, as well as lack of direct evidence to show that the petitioner is the daughter of DW2. The evidence of DW2 as projected father does not inspire confidence. With regard to the proof of relationship between the petitioner and the DW2 as daughter and father respectively. It may be stated herein that this is because of the fact that in none of the exhibited documents, comma, 7 except the affidavit within bracket exhibit 12. No, then, huh? The DW2 claims Josefa with the mother of the petitioner, whose name appears only in the voters list of 1977. However, it may mention that only in the deposit, in the cross-examination of DW1, the petitioner has disclosed her age to be 41 years. And her age was never disclosed in the written statement or evidence on affidavit. Most of the said cross-examination took place on 4/1/2022, and therefore the petitioner was born in 1981. In between 1980 and 1981. Most of our is but the existence of projected mother as stated by the DW2 has no existence beyond 1977. What is it of 1977? Next. Resultantly, the there is some mistake somewhere or there's some mistakes. বেলেগ এটা লাইনত লিখি ল'ব আপুনি the list of exhibits as at page 74 তাৰপিছত list of exhibit affidavit dated 27/10/2021 to explain discrepancies in name within bracket exhibit 12 you let not make it serial, huh? Notice of the tribunal within bracket exhibit 17. Then a notice within bracket, notice to DW3, exhibit 13. And exhibit 17 is the notice to DW4 for 17. Exhibit 14 is the authorization letter. Chitta book or original Chitta book, exhibit 15. Concerned page of draft Chitta within bracket exhibit 16. And 17 we have said it, this much, 17 documents. Accordingly, the documents, the pleadings, evidence and documents, the exhibited documents, number 1 to 17. It's to establish that the petitioner is a citizen of India and born out of Indian parents. Next, resultantly, the challenge to the impugn opinion fails. Opinion dated so and so, page 71 fails. The consequences of the said opinion would follow. Next. The writ petition stands dismissed. Next, the registry shall return back the records of FT case number 585 of 2018 and FT case number 256 of 2018 to the learned tribunal, along with a copy of the order to be made a part of record by the said learned tribunal. Next.
No, that's
Implemented in, while dictating your lordship. But the father, the petitioner, my lord, your lordship has dictated to you, whether my lord, the petitioner said that in the WSN and written, my lord, evidence, petitioner stated that, my lord, the Ojufa is the mother.
Petitioner?
Yes, petitioner, Ojufa is the mother in
Yes.
WSN, my lord, but in cross, my lord, say,
No, that
yes,
is what.
probably that, whether it is clear.
So just write it separately. In written statement
And
and evidence on affidavit, petitioner claims Josefa to be her mother.
yes, Ojufa to be.
So, however, in cross-examination,
Yeah.
he has stated that her mother is police
Police.
Devi.
Yes. But
To stop the father in the cross-examination stated that the Gulistan Devi is not the mother of the petitioner. but her mother is Josefa. It will correction. There's a criminal writ petition, item 16. Who's there? Okay. Because we may not have sufficient time, that's why we are. And item 14 is a.
Followed arm in the item 14. Worship, I appeared 14 for respondent number 4.
No, first is 16. The item 16 you are there. Item 14 also you are there, okay. Yes. Am I there? No. It's a criminal petition.
Yes, yes. Item 16, madam. 16, right?
Yes.
16.
16 criminal petition, here the government would also be required. Here there was no case against the petitioner, that's the
Yes,
issue, yes.
There was no case, my lord. Only thing is that, my lord, they were detained, but later on they were released. They were released, but there was some delay while releasing, my lord. That is the only point.
You have to tell us how much compensation.
My lord, it was purely on, my lord, mistaken identity. I apologize
No,
for
but-
that, my lord.
No, not that. You see, this apology.
Yes, my lord, your
will be,
lordship.
Problematic because of the fact that under the Assam Police Manual.
I admit, my lord, there is that fault on our part, my lord. So yes, your lordship.
Arbitrary is. Fine, you come back day after tomorrow. We are proposing to pay to the petitioner, direct the state to pay the petitioner compensation rupees 50,000. You have a word with your authority. So we are being lenient, what do you call this, compensation is big in the lower side. That's why we are asking you to have a word with the authorities. But when we have to decide. No, that's all, but if we have to decide, then that may not be the amount. Day after tomorrow. Speak to them. We'll not record your consent, but you have to be made aware. So this, unless we do it, it will be a rampant picking up of people without the showing of the identity. That hits Article 21. Okay. You, in the meantime, you have a word, because this matter we may not like to take it up. Just say, both sides are represented. List this matter before any other bed without one of us within bracket Which is the- In the meantime, you get instructions,
Yes, ma'am.
not before this. Yes, item 14 now.
May it please your lordship. As I appear for the petitioner, unfortunately, my senior is unable to appear at this moment. So if the matter may be listed post 3rd of Feb, I'd be much grateful.
Lordship will please have the order of 19/12/25.
What is that?
Lordship, there is an observation that given the urgency and also the fact that there is an IA for vacating the stay pending, that the matter will be taken up for final disposal on 8/1, failing which the IA for stay vacating would be taken up. Lordships, I'm only praying that perhaps if a date is fixed, that observation may be continued.
Manoj, I have strong instructions to oppose that. My senior is instructed to.
Then
seek
start
an-
your argument, we are ready to hear you. But then the interim order would be vacated now. If you are objecting to that prayer, you see, he was reasonable, he was saying that please continue that observation for the next date. He did not urge for the hearing today for the stay vacating application. But if you oppose that prayer, we are going to vacate it right now. Unless you start your argument right now.
Manoj, that is something I am unable to do because.
Then we are vacating your interim order right now. We record what is transpired in court and we are vacating it. You must know when to make a prayer. Your strong objections, we have taken it very strongly. But if you don't have the urge to argue, your interim order goes. We give you 5 minutes time. You start your argument. We give you five minutes time to.
Manoj, may I contact
Please,
my
yourself.
senior then if he's.
Please,
Sure.
5 minutes. For other matters, the matters will be adjourned because we will not be able to have time to take it up.
Item number 5, what happened in this case, Miller? In 2020, Miller, matter was dismissed, Miller. Subsequently, matter was, brief was taken back by the client, Miller.
No, you have a lifeline now.
Yes.
Today it's being adjourned. You get up. Very
But I have gone through the record, Miller, that's why, Miller. The subsequently review petition was filed by the DP Solia, senior advocate. That review petition was allowed and revived the petition, Miller. But the brief is not returned back to me, Miller. Returned back. That's why, Miller, I have not charged the.
Here we can't take cognizance of that.
Yes, Miller. That is the problem, Miller.
You,
Hasn't taken.
you have a lifeline now.
Otherwise, Miller, the case is
You have all 3 lifelines. Phone a friend.
already informed the DP Solia, Miller, senior advocate, about the matter today.
Reach out wherever you want.
Hmm.
You have all these 3 lifelines.
Since morning, I am waiting.
So that's why we are adjourning it. We have seen you. We give you the benefit of a lifeline now.
Oh, please.
Lords, apologies for the inconvenience. Unfortunately, my senior has instructed to convey to the court the great inconvenience that has been caused. And if the matter can be taken up tomorrow, my lords will be very grateful.
You can understand that what you have done is disrespectful to the other side. He does not give you that opportunity. He said that merely since the time is not there, please extend that observation for the next date. And then you make a strong protest. If it is strong protest, then we take it up. Time is no constraint. I have a habit of sitting here till, I have been holding court here from till 8:30 is my last time which I have held court.
My lords, I very well understand and appreciate
No, I
that.
don't appreciate.
But on
I
8th
listen, I don't appreciate.
but on 8th of Jan, the matter was not listed. So if the matter can be taken up
No,
tomorrow.
I understand. Get us an order from any other authority saying that we must take it up on a day-to-day basis. From tomorrow, we'll take it up at, tomorrow start at 9:30, we'll take it up at 9:30 tomorrow morning.
Tomorrow, if it can be taken up, I'll be much grateful, my lords.
You'll have to start the argument now. We continue till 8:30. If it fails, then 9:30 tomorrow we start again. Other court works cannot be disturbed. You don't have the right to take the court to ransom. You don't have the guts to argue, you don't have the preparation to argue, and then you make strong objections. What was wrong in the prayer of the other side? To have that observation extended for the next date of listing. What was so bad about it that you had to strongly object?
My lords, my instructions.
And then when you can't make an argument, then you say you are sorry. You want to bully the court.
Not at all, man.
Then what was the intention of saying that you have strong objections? If you have strong objections, start your argument. Why you are wasting time of the court? And then you want the court to take up the matter as and when you want. We'll take it up at our convenience now. You don't have a fixed date when you don't have the urge to argue the matter. We'll give you a date. It's convenient to you or not convenient to you is your lookout. Don't force us. The entire day we have been holding the court in a peaceful manner. I don't come to court to shout at the learned counsel. Have you seen that behavior of the court from the entire day? That's what you saw. We are misbehaving with the advocates. That's what you saw.
Not at all.
You said yes. Don't force us to an extent that we'll retaliate. We know how to retaliate. We don't do it because that's not my nature, not the nature of my brother. And you have strong objections.
That's my only prayer is that the matter may be taken up tomorrow.
No, we'll take it at our convenience. And you'll have to come when we tell you. We don't take now, from now onwards, in your case, you'll not take as per your what you call, your convenience. We'll take up as per his convenience. Whenever he says, we will take it up. Yes, when do you want?
Chips, my suggestion was that since Learned AG and some other senior counsel are involved, so perhaps in the first week of February, we can give
Tell us a date, we'll give you on that date.
Chip, perhaps. Okay, perhaps 12 February, it's a hearing,
or 10th,
or even 10.
10th.
Lordships, I'm so sorry, perhaps fifth or
third.
Fifth,
No, we have already fixed matters. 10th is okay.
Lordships, may I pray for 11th or 12th?
11th is our motion day.
12th.
10th.
Okay. Both sides are represented. Due to positive time, the matter could not be taken up today. Good stuff. Next, by order dated 19/12/2025, this court had provided that if for some reason the matter cannot be taken up cannot be heard, or the application for vacating the interim order will be taken up for consideration. The said observation is reiterated. Next matter, this is the matter for hearing on 12/10/2020, yes, or 12/2/2025, 26. Interim order passed it is and printed with the next day of the state.
Much obliged.
Okay.
My lords, my apologies, sincere
It's
apologies.
okay. You don't think that we don't want to work. If you want, we'll come here at whatever time we want to see. You want us to start the court at 9:30, we'll do it. We are not afraid of working. It's just the paucity of time. We have many other engagements. But it's not one matter we are dealing with. We have many other administrative works to do. We have many works to complete. All in at least in this bench, you will find daily orders uploaded unless today 2 orders were passed, long orders may not be transcribed today. No pending matters here. Don't tell us that as if the court doesn't want to take up the matter. No. This sort of bullying we will not